Well, ladies and gentlemen, I think we can get started with day 2 now. And the topic is the document section of the Act. Now, the portion I'm going to deal with mainly deals with the hearsay provisions as they relate to business documents and computer printouts, in particular, computer printouts. Now, there just isn't time to deal with all the document provisions of Bill S-33. In order to emphasize what I think are the most important parts, I'm leaving out the public document provisions. I think they're reasonably straightforward, and I think by making a simple comparison between Bill S-33 and the public document provisions of the Canada and Ontario Evidence Acts, that you would pick up most of the differences without the need for a great deal of analytical commentary. Now, another reason for my concentration on computer printouts is because a good deal of the work that I did for the task force ended up in a large dissenting paper, which I gather was too large for the report of the task force. I think it contains a great deal that could be used in court proceedings. And some of that is in the paper before you. Now, considering that most documents that come to court come by means of a computer, by and large, lawyers aren't aware of that fact. And in fact, maybe I would think many of the witnesses who produce those documents in court from their filing systems might not realize that those documents are the product of the computer. They might not realize, for example, that the computer may do the sorting and searching for particular documents. Computers are different. I think they're very different from traditional record-keeping systems, and therefore the traditional requirements for admissibility should be different. But by and large, in Bill S-33, they're not. Now, Bill S-33 will accomplish some improvements if it becomes law. It'll make clear that computer printouts, I think, are admissible. It'll make clear, secondly, that multiple hearsay is admissible. That's particularly important. It'll make clear, thirdly, that opinions are admissible. Fourthly, it will make easier, I think, the recognition of evidentiary issues as they relate to documents. And the reason for that is that the three major groups of evidentiary issues are separated into three groups of sections in the Act. What is often not realized is that evidentiary issues as they relate to documents do fall into those three major categories, and they are problems relating to the hearsay rule, secondly, problems in relation to the best evidence rule, which just simply means the problems of copies, duplicates, and other types of secondary evidence. And thirdly, the problem of authentication. That is, how do you prove the other two? How do you prove the hearsay exception conditions precedent? How do you prove the foundation evidence which goes to obtain the admissibility of computer printout? How do you prove whether something is a copy? How do you prove whether something is made in the usual and ordinary course of business? That's authentication. Authentication provisions would be provisions such as words would say, the manager of the record-keeping system shall give the evidence, or a qualified witness shall give the evidence, or the evidence shall be given in an affidavit by a knowledgeable person, or the evidence shall be given by a person who was present at the destruction of the record. An example of that is contained in Section 31 of the Canada Evidence Act, which is referred to as a photographic document provision. It really is a best evidence rule provision. Photographic document provisions are. What is often not realized is they really aren't hearsay provisions. We tend to merge all of these evidentiary issues under the general category of hearsay. Therefore, Bill S-33, I think, accomplishes a very important trial administrative purpose in separating these three categories into the three major groups. Now, on to computer evidence and the foundation evidence necessary. Could you turn to page 251? Now, what I'm going to try to do is outline the arguments on both sides of this issue. The point being, computer printouts are really the source of most documents going to court. On that page, I've set out in 2 columns the relevant provisions of Bill S-33 and their source, which is the Canada Evidence Act, Section 30. Now, it is my argument, and not only my argument, that of other writers, and the reason I use the word argument is because it means that there are opposing arguments. The point isn't clear. The point being that the circumstances of the making of a record can go to its admissibility. Now, to understand that, let me put the opposing argument. The opposing argument would be, no, if a document is made in the usual and ordinary course of business, it goes into evidence. Everything else, which would come within the category of circumstances, goes to weight. Now, the paper contains an elaboration of the first argument. That is, because of the way Section 30 sub 6 and sub 9 are worded, they can bear upon and control the admissibility rule, which is in 30 sub 1. The result being the circumstances of the making of a record can be seized upon, any of them that the judge thinks are particularly important, can be seized upon as a reason for excluding the document. Now, in a traditional paper record-keeping system, that might not be particularly important. Traditional systems often tend to use traditional practices. Computer systems, because they divide the making of a record from its imprint on paper, from its recording is separated from its indexing. Its temporary records are separated from its permanent records. Because of the ability of storing knowledge in a flow of electrons before committing it to paper, all of these traditional systems and principles don't have to be part of a record-keeping system. Therefore, it should follow, if the law is properly reflecting business practice, that the criteria of computer printout admissibility should be different. Now, the majority of the task force didn't agree with me, and the Uniform Law Conference didn't agree with that portion that the majority of the task force was willing to adopt from the arguments which I presented. I should say it was my responsibility to do the workups of the initial study papers in this area. Now, what flows from this fact? If the argument is held to be true, that the circumstances of the making can affect admissibility, well, suppose you were examining or cross-examining a records manager. You have records that come from a large organization, and if it's the typical way records are put in, somebody from the filing system will be there. It probably will not be the executive having overall responsibility for the record-keeping system. Let me take a system which should be the hardest to crack, banking records. The Crown or the person proffering the records will argue banks are very well regulated. Therefore, we should accept their records automatically because they come from a banking system. Nothing more need be proved. It's from a bank, my lord. And then a hush should follow, and the document should go in without question. Well, the counsel on the other side, I think, should examine the witness and point out that the banking accounting, the responsibility for all the entries on the records is no longer in the bank branch from which the records come from. There's merely a paper bridge from the data center to that particular bank branch. But our legislation at present still looks to an affidavit coming from the branch accountant or manager. Now, the essence of reliable evidence is whose responsibility. The reason why we allow an exception to a hearsay rule is first of all a necessity, and secondly, because we've been able to supply at least some conditions which guarantee reliability. Given the traditional banking system, which no longer obtains, our present provisions in Section 29 of the Canada Evidence Act and the Ontario Evidence Act make sense. We get an affidavit from the local branch manager. That manager or that accountant has control over the particular employees who work for him. Mary Jane at the teller, at the wicket, who's the teller, she takes the deposits, the withdrawals, knows the customers. That branch accountant has responsibility over Mary. If there's a bookkeeper who does the accounting, that accountant has responsibility for what she produces. Therefore, if we receive that accountant's affidavit, we have a person who is sworn to a document relating to business transactions for which he has responsibility. We're therefore justified in that factual situation in creating a hearsay exception. We have deprived the opposing party of an opportunity to cross-examine directly the people having direct personal knowledge of the facts and events which are recorded on those banking documents. That is the main impact of the hearsay rule. It deprives of the opportunity of hearsay exceptions. It deprives of the opportunity to cross-examine. In compensation, we say, but there's a necessity. We won't have litigation properly conducted unless we create an exception. And we've also supplied certain circumstantial guarantees of reliability, as Wigmore says, in their place. We'll give the opposing party notice so that he can prepare to make sure that the conditions precedent are satisfied. That is the theoretical structure upon which hearsay exceptions are created. Let's adhere to it. It doesn't matter that we have computers. The idea of someone responsible is still the essence of reliable evidence. The opportunity to cross-examine or else have good conditions precedent in their place still is a valid theory and principle in support of the reliability of evidence. If that factual situation, if that common sense approach to evidence is displaced, we will not have reliable evidence. So I say to you, ladies and gentlemen of the jury, when you're at home and you get your bank statement every month, do you accept it automatically? When you get your charge-ex statement, do you go over every amount? Does it disturb you that with some credit card companies you don't have what they call descriptive billing? That is, that you also get their copies so to know what they say is the reason for those entries. Have you never found a mistake on your MasterCharge or Visa card record? Have you ever noticed when you go into a bank that the turnover of tellers is quite rapid? Have you ever read in a newspaper about people being charged because they took a deposit or withdrew money from their account because the deposit was wrongly entered into the account? Somebody made a mistake and put the money in the wrong account because somebody made a mistake at the computer. Well, those are the types of mistakes which are guaranteed to end up on any banking document. And if the mistakes can be made in one area, they can be made in all areas. Now, no matter what the system is, of course, there will be mistakes. The question is, are the circumstantial guarantees of reliability there? If they are, we in the courts are justified in accepting the evidence and enduring the risk. If the circumstantial guarantees of reliability aren't there, we are not. It is not sufficient to accept the argument that the banks have a certain need for business convenience. Reliability is still the required criteria of good evidence, or rather responsibility. Let's take something even more complex than documents. A bit more complex, maybe no longer a great deal more complex. Let's say medical evidence, or the evidence that an accountant may give, or an engineer, or any other professional. That is full of hearsay. It's constructed often on a total foundation of hearsay, albeit professional hearsay, nonetheless hearsay. Why do we accept the evidence of the doctor and accountant? He comes to court, not only does he talk about things he doesn't have direct knowledge, he tops it all off with a professional opinion based upon that mountain of hearsay. We have no difficulty with that. And the reason for that is that he's there, he has professional standing, he testifies to his qualifications, he indicates to us, if he's giving his evidence properly and has been thoroughly prepared, he indicates to us the professional criteria, the principles that are accepted in his field that he applies in order to sift the evidence. And then and only then does he finish with his opinion. And then he says, by his continued presence in the witness box, I am here. I swore under oath, a condition of a guarantee of reliability. I am here to be cross-examined, another extremely important guarantee of reliability. Well, that leads to 2 points. Number one, if you can, attempt to have the records manager qualified as an expert witness, because then you can move over into a different area of the law of evidence, a much more comfortable area than the area of business documents. Judges are quite used to accepting the evidence of experts. Secondly, it indicates, I think as well, what a poor tool the hearsay rule is for complex areas of opinion making. It is really an extremely poor second-best tool. I suspect that within 10 or 15 years, many legal commentators will be saying that the hearsay rule is really not capable of compensating adequately, and perhaps this will just be the fault of the lawyers and legislators, adequate for compensating for the complexities of computerized record keeping. Lawyers don't know enough about the differences from traditional record keeping. Now, we've displaced our banking records to the data center. We get the affidavit from the local branch. Where's the responsibility? The bank says, well, we continue in business, we make a profit, it's accurate. The accused or the defendant says, I want the opportunity to cross-examine. It is not just that the records by and large are accurate coming from the banks. What about my right to confrontation? I want to confront the witnesses who are against me, who create the major pieces of evidence against me. And the more we get into white-collar crime and civil litigation, the more we will depend on not just banking documents, but business documents created by people who are not responsible for the information that they contain, unless we create the criteria in the Evidence Acts which substitute for our traditional criteria. Now, the business manager from a large corporation, perhaps, or should I say the records manager, can be tested rather vigorously in regard to recent developments having to do with computerized record keeping. Remember the main foundation of my argument, that all of the circumstances are open. All of the circumstances which go to make up that computerized printout which comes to court. Now, even if I'm wrong, and the circumstances don't go to admissibility, but they only go to weight, you can certainly have an extremely large impact upon the finder of fact. You can ask that manager, what are the sources of the information which go into the record-keeping system? And if the person doesn't have sufficient knowledge, they won't know. Just as the bank accountant could likely not describe the processes that are carried on at the data center. But yet we take his affidavit, and his affidavit is completely dependent upon a multitude of computer programs that he can't swear to the reliability to. You could ask that person, well, could you describe the check clearing system that's used by the banks? Do they always microfilm every batch of checks that is cleared every day? Have you ever seen a flow chart of the check clearing system that's used by the banks every day? It is a very long piece of paper, and it has many, many branches. Well, of course there can be mistakes. Let's at least get someone who can swear to the accuracy of the procedures that were applied on the particular day that the banking documents were produced. Now that applies equally well to any organization which uses computerized record keeping. The computer now not only takes the initial entry, it indexes them, it sorts them, it prints it onto microfilm. So far, I haven't mentioned anything about paper. No paper is yet created, and it stores them. When someone wants a particular record, in many systems, they can consult the computer. The computer indexed it, and the computer can retrieve it. So you have information untouched by human hands. Then finally, someone says, well, let's print it out on paper. And this can be months after the particular facts or events which are on those records happened. So you can see that the document that doesn't come to court doesn't have contemporaneity. You ask that witness, this piece of paper which you brought to court, this computer printout, when was it made? Well, I just made it before I came to court. This record was not made contemporaneously, my lord. Well, no. Well, was it made in the usual and ordinary course of business? Well, depends on what's usual. Is that subjective or objective? Bill S-33 doesn't define it. Is it peculiar, subjective to the business that's involved? We're not told. We're told that computer printouts are admissible. We're also told in section 155 that the court is to have a look at the total circumstances of the making of the record. Well, let's look. Mr. Record Keeper, you can't tell us about the sources of the information. Can you tell us whether the people who supplied the information were under a business duty? My lord, I'm putting these questions in this form because your lordship will hear my argument later that these factors arise out of the cases pre-existing Bill S-33. Well, says the witness, I'm not sure if they came from people who were under a business duty. Well, what about the recording of the information? Well, yes, that was done by people who are within our organization. Well, how many times was the information handled before it was finally put on this piece of paper? Oh, well, it goes through many, many steps. Well, I imagine I know that, witness, but how many computer programs is that information massaged by? Is it in the original form in which it was entered? No. So we don't really have an original, my lord. Well, can you tell me who wrote the computer programs? Oh, well, we buy our software from various places. How much of the information on this document was processed here in Toronto? You're just a branch, aren't you? Yes. Have you heard of transborder data flow? Yes. How much of your accounting practices is done south of the border? Oh, some of it are sales figures, that sort of thing. Do you have any witnesses here who applied those computer programs down in Chicago? No. Well, I take it then you can't tell us anything about the business duty that applies to the people who supply the information, what the sources of the information is. You can't tell us how much of that information really results from south of the border. Can you tell us about how much of that information is computer stored as distinguished from computer generated information, computer created information? I think, my lord, that's, as my argument will show, it's a valid distinction. There's quite a difference between a computer which merely stores acts and facts and a computer which massages the data and in effect applies its own opinion to it in the form of applying computer software. Well, the records manager says, I'm not sure. We have many pieces of software that we apply. Oh. Well, what happens to the information? How is it stored? Well, we have a COM unit, COM, computer output microfilm. That takes the data and it puts it right on microfilm. We're very proud of our microfilm system because it saves a lot of storage space and much more difficult to alter microfilm. We get a lot of security out of microfilm. Oh, when was the microfilm program established? Well, I'm not sure. I take it that the microfilm program is an integral part of the computer. Yes. The microfilm program, I gather, is the basis of your whole record-keeping system. Yes, it is. Was there written authorization to establish it? I don't know if that's necessary now. We've been using it for years. Well, when did you switch the microfilm program over to the computer? Well, I don't know. Are you familiar with this document, witness? This is a national standard of Canada. Microfilm is documentary evidence. Oh, I don't think I've ever seen that. Well, when you pick up your kettle or any electrical appliance, you see that CSA symbol on it, Canadian Standards Association. We all know that there are standards for electrical appliances, and many of our consumer products have standards. Those standards are created by national bodies. Well, did you know, witness, that in regard to that record-keeping system, which is the foundation of that multi-million-dollar organization that pays your salary, that they have also written a microfilm standard, a national standard of Canada? Now, what I'm going to do, witness, is go through the paragraphs of this standard and cross-examine you and find out how much of that microfilm system that produced the paper you brought to court conforms with this. Well, I won't take the time to do that now. Witness, what about the income tax requirements? Are you familiar with that? Well, I don't know. Which requirements are they? Well, you are the records manager. Yes. Well, this is Taxation Canada Information Circular 78-10R. Oh, well, I leave that to the lawyers. Did the lawyers bring it to your attention? No. Do you know, witness, that there's a portion in this income tax bulletin which is headed up Methods of Keeping Records? Now, this is a bulletin meant for all organizations. And it cites this standard. And it approves a particular method of keeping microfilm. When you come to court and bring us records, and you can't tell us as to whether they conform to the ordinary standards of an organization, of Canada, national standards. Witness, I'm going to show you a diagram. This is a diagram of a computer system, terminals. It indicates very simply how, where the terminals are, where the CPU, the central processing unit, is, how microfilm, how the data is stored and retrieved. Show you another diagram, which is very similar to what I gather your organization is. This is a diagram of a fully automated records management system. The computer takes the information in, it sorts, indexes, and retrieves. Witness, could you draw us a diagram of your particular computer system? Did you bring a diagram? Now, from what I've heard today, witness, your system is every bit as complex as any we've heard of, but yet you can't diagram it out. You seem to be very proud of the fact that the information is taken in, massaged, changed, and untouched by human hands, and the computer retrieves it all. Who, witness, has responsibility? The prosecution or the plaintiff here is wanting to penalize my client on the basis of your records. It may well be, witness, that your records are totally accurate, but all I ask is that you be able to prove it, and you can't. If you haven't got a flesh and blood person up there who's willing to say, I can give you a description of how the record-keeping system works, I can describe the circumstantial guarantees of accuracy, I will put my professional opinion, whether I'm professional or not, maybe I'm just the filing clerk, I know how the system works, and I will swear that that record-keeping system is accurate. If you don't have a person like that, we have no business accepting documents simply because they are created in the usual and ordinary course of business. Now, there are other documents that you could use very effectively against witnesses, particularly witnesses of large organizations, and even witnesses of small organizations, because you will be surprised how prolific the computer is. It's into almost all business documentation one way or another. You may have witnesses who come to court and say, oh, no, we don't have a computer in our premises. Well, we have a terminal, but we don't have the computer. We use an outside computer service. We just enter the information upon a terminal, and it flows by line a few blocks away, and we receive a paper flow back at night. Well, witness, why isn't the person who operates that external service here? Well, I don't know. Ask the prosecutor. You could also ask the records manager about records retention. Does he know anything of the requirements of the law in regard to how long documents are to be kept? People will bring paper to court, but that paper is often the product of microfilm or of a computer. The originals may have often been destroyed. There are two very important documents in the area of records retention. What I mean by retention is the federal and provincial legislation specifies periods during which documents must be kept. And those periods are presently being rationalized into 7 groups. And that's what these two documents do. Right now, you can find, I think in the federal legislation, 67 different statutory retention periods. Anything from keep it for life, keep it for 2 years, keep it until the minister says you don't have to keep it, or the income tax people said you don't have to keep carrying it around. The federal document is called Records Retention Requirements for Business. Those of you who have business clients will find this very effective, very impressive to those clients that you know of these documents. And it is put out by the Small Business Secretariat, which is a division of Trade, Industry, and Commerce in Ottawa. It was originally compiled by an organization called the Paper Burden People. That agency was dissolved after it had done its work. The Ontario document is called Guide to Records Retention Requirements. It is put out by the Management Board of Canada. Another document which can be used very effectively, I think, in cross-examination is the Creever Commission report. Now, this is volume 2. I'm not saying that you'd say to the records manager, have you read Creever? He's in records and not in medical health. But the chapter on computer systems is very good, and it sets out very well the concerns that people have in regard to computers. If I were opposing the prosecution on a case which was largely based upon computers, I would use that report by emphasizing the main points that it makes. The report discusses the difference between computerized and traditional paper record-keeping systems, and the main points that that chapter in Volume 2 makes are these. The establishment of new databases and systems of collecting data to put them in is extremely easy. Members of the public feel they are not in a position either to determine what data must be shared or how well they are to be protected. 2, the great density in which data can be packed allows an intruder to easily carry off many thousands of records and to be non-selective. Non-selective access to large numbers of records was impossible when records were kept on paper. You can put the whole library under your arm and run. That's what it means. 3, computers make possible invisible theft, as it's called. That is, stealing data without actually removing any physical object by transmitting data or making copies without altering the source data. 4, computers allow large numbers of copies of data to be produced very quickly on high-speed line printers or on computer output microfilm, that's COM, C-O-M. Thus, getting what are called silent copies is far easier than with paper. 5, the greater ease of altering data by writing over magnetically stored data without leaving a trace. And 6, the collating of data which were never intended to be brought together by linking computer systems so as to link different kinds of records. Thus, computers can greatly facilitate a non-selective access to masses of data. It takes time to steal the right information, but if you can steal all the information, either physically or through a distant computer terminal, that makes the computer system much more vulnerable. Now, the report stresses that these differences can be compensated for by security procedures, which have been developed by the data processing industry. But in my discussions with records managers and data processing people, they're very concerned that the security features are being applied much more slowly than is the new software and hardware of data processing. And you will find that many records managers really can't describe the security features, mainly because there may not be any control of access to terminals, and it may well be that it's extremely easy to alter the data. Many records, in fact, never hit a filing system because the ease of creating a temporary record. You can put it up on the screen, take off a copy off the printer, and never memorize it into the CPU. And therefore, this is an area of concern because when a witness comes to court, he'll often start his evidence by saying, yes, I searched the records and found only these documents. And in fact, there may have been many other records which never did reach the filing system. Now, I've emphasized the differences, and the point of much of the paper is to indicate that the traditional criteria of paper record-keeping systems are not adequate. There are appropriate criteria which have been developed in the legal literature, particularly south of the border. We can, in fact, prove that that records manager does have a reliable system. The point is not that there's no way of showing a computer system accurate. In fact, there is. The point is rather that the criteria are different. Now, the second point flowing from the first argument being the importance of the circumstances of the making to both weight or admissibility as well as weight, that the second point is that we're going to have to educate the judge. If lawyers become knowledgeable about record-keeping systems and begin to push and probe the records witnesses that come to court, then we're going to have lengthy voir dires and lengthened trials in order to determine in each case what are the necessary circumstances. My second point, therefore, is that it would have been better if the legislation had have occupied the field. What I mean is set out what the standards should be, not in great detail, but the basic requirements of a good record-keeping system, computerized record-keeping system. Then, when counsel came to raise many of the arguments I've raised and hold up the documents, the judge would only have to say, counsel, that's all very interesting, but I think that unless you can show us that those factors have led to errors in fact, they are irrelevant. The legislation has established what the criteria are. Those are the elements to which your learned friend has directed his foundation evidence. I've indicated that that foundation evidence satisfies those criteria. Now, unless you have some evidence in opposition to indicate the weakness of his evidence, I can see no reason why I shouldn't let the records in. There are many other ways of conducting a record-keeping system, counsel. However, they don't relate to the particular factors that are in the legislation. Now, contrary to that, Bill S-33 hangs on to that single phrase, usual and ordinary course of business. It leaves to the judge in section 155 and 156 a wide power to investigate the circumstances of the making and leaves it to him to decide what a good data processing system or microfilm system should be. Well, if you have a knowledgeable counsel, I suppose the judge will be committed to a long investigation of that system. Here are the conditions precedent that I think should be in the legislation. The importance of my giving them to you now is that you can use them as factors for interpreting Section 30 of the Canada Evidence Act, particularly subsection 6, which deals with circumstances, and as well Section 155 and 156 of Bill S-33 should it become law. They are also relevant to Section 35 of the Ontario Evidence Act because it indicates, of course, that the circumstances of making a record go to weight. So these 10 factors would provide an outline of an examination in chief or a cross-examination. First, some proof of the sources of the information recorded in the databases upon which the printout is based. I might say these factors are not in the paper. No. I mean, they're not gathered together in a list. I'm trying to shorten the paper. Number one, proof of the sources of information recorded in the databases. I think that's an obvious common sense factor. If you can't tell us something of the source of your information, then it's just simply a situation of garbage in, garbage out. Number 2, proof that the information in the database was recorded in some fashion contemporaneously with or within a reasonable time after the events to which such information relates. You can call that one contemporaneity. Now, there's an important difference there from traditional common law contemporaneity. In common law, the record that came to court had to have been made contemporaneously with the act or fact it recorded. What I'm saying here, the computer system need merely, or the records manager, need merely prove that there was some record made contemporaneously. Human memory fades the longer we wait between the act we want to record and the actual recording of it, and mistakes creep into our recollections. Make it on a scrap of paper, make it on the computer terminal, make it on the back of your cigarette box, but make it contemporaneously. Later on, it can be passed on to more permanent documents massaged by computer printouts, but the records manager will come to court and say, yes, here's the contemporaneity factor of our usual and ordinary course of business. No matter how sophisticated DP systems become, electronic data processing systems become, if people, the witnesses, cannot tell you something about the sources of the information, they can't tell you that the acts and facts were recorded contemporaneously with the events, then the record-keeping system cannot be sworn to as being accurate. 3, proof that the data upon which the printout is based is of a type regularly supplied to the computer during the regular activities of the organization from which the printout comes. We have regular data, if you want a short form for that one. In other words, we don't want special information contrived for these proceedings. 4, the foundation evidence should require that the information upon which the statements in the printout are based would in itself be admissible as evidence supporting those statements. The information is otherwise not caught by other rules of evidence. For example, rules as to privilege. 5, proof that the entries into the database upon which the printout is based were made in the regular course of business. That deals with the entering procedure. The previous one dealt with the information procedure. 6, proof that the input procedures in adding to the database conform to standard practices in the industry. Now, that one is the only one I'm not absolutely confident about. It is a prospective factor. I'll read it again. Proof that the input procedures in adding to the database conform to standard practices in the industry. Well, right now, there really isn't a consensus of opinion as to what the standard practices in the data processing system industry should be. I'm assuming that eventually they will emerge. Just as they emerged in the microfilm industry, those people, the microfilm experts, are way ahead. They have several standards as to how you microfilm, the chemicals, the procedures, the authorities necessary to set up a microfilm program. This particular standard I referred you to is the one dealing with legal evidence. The data processing industry has not developed comparable standards yet. 7, proof that there has been reliance upon the database in making business decisions within a reasonably short time before or after producing the printout sought to be admitted in evidence. I'll give that to you again. Proof that there has been reliance upon the database in making business decisions within a reasonably short time before or after producing the printout sought to be admitted in evidence. Now that, I think, is particularly a powerful factor to bring out of the witness. You can say, now, witness, I'm going to ask you a few questions in re-examination. Now, the opposing counsel showed you a bunch of documents, and he raised all sorts of possibilities, speculative possibilities as to the weakness of the bank record-keeping system. How long have you been using this system? Does it give reliable information? Are business decisions made on that record-keeping system? Have business decisions been made in relation to the information, the documents, which you brought to court? I think that demonstration of a history of reliability can sweep away a lot of the speculative possibilities that can be raised. That is, the telling of horror stories through clever questioning of witnesses. Well, for example, I think particularly effective would be to bring out the fact that much of the data processing of an organization is done hundreds and thousands of miles away by people who have no accountability in our jurisdiction. Well, you can bring out of your local witness the fact that they've been relying upon this information and the whole business is based on it and is very profitable. I think that will answer a lot of that. Number 8, proof that the computer programs in producing the printout reliably and accurately process the data in the database. Now, it might be that depending upon the strength of the opposition from the opposing counsel, that you'll need 2 witnesses instead of 1. The records manager and the person who applies the computer programs, or it might be the person who wrote them. And that's what number 8 relates to. Proof that the computer programs in producing the output reliably and accurately process the data in the database. Number 9, proof that from the time of the input of the data into the database upon which the printout is based until the time of production of the printout, records have been kept by a responsible person of alterations to the mechanism and processes of the computer during that period. What that relates to, in short form, is a record of alterations to the mechanisms and processes of the computerized record-keeping system. 10, security features. Proof of the security features used to guarantee the integrity of the total record-keeping system upon which the printout is based, and of the effectiveness of such security features. Now, there is a second section that I would add to that list of 10, and what it deals with is the question of security. What it says basically is that the judge should have regard to the fact that that security should vary with the type of information that's involved. We shouldn't require the same degree of security precautions of, say, a telephone book or an airline's reservation system, even though it's computerized, as we would of a computerized medical record-keeping system. So that there has to be a sense of proportion in regard to security. Now, the task force did indicate that there should be some requirements for computerized records. And just find the particular page. Yes, at page 290. You'll see there section 171 in the middle of the page. Now that was from the task force's draft act. Now that draft went to the Uniform Law Conference, and after its changes, the Uniform Evidence Act was produced, and then Bill S-33 is based on the Uniform Evidence Act. So you might say that this is from the very first draft of the Uniform Evidence Act. 171, and it was rejected by the Uniform Law Conference, and therefore it doesn't appear in Bill S-33. You can see there in 171, subsection 1, 3 factors. They are, I think, 3 of the 10 that I read out to you. Now, the task force document is a document of some authority, and therefore you can use it as a source of structuring your examination in chief or your cross-examination of witnesses who produce records. I've reproduced in the paper there the commentary from the task force report in support of these criteria, 190 and 191, and then near the bottom of 191, you'll see indented there the reasons of the Uniform Law Conference for rejecting the task force recommendation. I'll just read that. Rejected, members of the majority expressed the following reasons for their decision. 1, if a computer printout is used by a business in its usual and ordinary course of business, that provides sufficient guarantee of reliability. Now, most of what I've said, I think, goes to refute that. 2, the provisions in the recommendation would require the calling of many additional witnesses. In answer to that, I would say that's totally wrong. It can be done with 2 knowledgeable witnesses, the list of 10 requirements. And it's being done in other parts of the world with just 1 and 2 witnesses. 3, in some cases, it would be impossible to satisfy the conditions even though the evidence was reliable. Now, keep in mind, that is a rejection not of my list of 10, but of the task force's list of 3. I don't think the Uniform Law Conference gave sufficient attention to computerized records. I think there will be a very large fragmentation in the case law. It's beginning to occur now, and a good part of this paper deals with that fragmentation of what's happening. We're going to find cases which emphasize different criteria that existed at common law. Some will require that the person who supplied the information be under a business duty, and then that be proved, and that the person who recorded the information be under a double usual and ordinary course of business requirement. You'll find that discussed in the Ontario cases. Bill S-33 has sought to escape that dilemma. Other cases have looked to the question of opinion and have rejected opinion evidence. Bill S-33 attempts to include opinion evidence. Now, the importance of that lies in the fact that one can raise a very strong argument that a computer printout is an opinion. It is the opinion of the computer, or the opinion of the computer's software programs which are applied to it. Counsel should emphasize the fact that the data as it comes out on the computer printout is most often not in the form in which it's entered. It's been massaged, evaluated, analyzed, and reformatted. And therefore, in effect, you can look upon the computer printout as an opinion. Well, we should have a responsible person to evaluate, to certify the accuracy of that opinion, just as we do with all expert opinion evidence. That was one of the purposes of that list of 10 requirements, that in compensation for the fact that printouts are opinions, we have other criteria. They exist in the legal literature. I'll close by referring you to 2 other lists. On page 289, there is set out in point form the special computerized legislation from the United Kingdom, the Civil Evidence Act of 1968, and the South Australian Evidence Act. Those provisions came into effect in 1976. Again, that's a point form outline that can be used to structure an examination in chief or a cross-examination. You can take those and say to the judge, Your Honor, I suggest that is what we should read into section 30 sub 6. I suggest that's what we should read into section 35 sub 4 of the Ontario Evidence Act as to what the circumstances of the making of a record should be, and I suggest that is what we should read into section 155 of Bill S-33 and 156. Other countries have taken the course of providing specialized computer legislation because computers are different. Most recent of all is the legislation from South Africa, which is currently in the South African Parliament. I reproduced at the very back of the paper, starting at page 302, the Computer Evidence Bill. And in the right-hand column of those pages to page 305 are the requirements that would go into an affidavit. You'll see many of the requirements there are very, very similar to the list of 10 that I read out. And it's intended in this legislation that they all be in an affidavit by a single witness. So I think there's absolutely no basis for an argument that the criteria that I suggest, or even the much more modest criteria that the task force suggested, cannot be proved by one witness. At most, two, if you have a very complicated set of computer software programs to supply. In fairness to the bank record people, let me close by referring you to two lists. Page 280. These lists sum up the pages prior. Page 280 is a summary of the argument that the Council can put in support of the admissibility of computerized banking records. On the other side, on page 276, are the opposing arguments if one wishes to keep bank records out. On page 273 is probably still the most important quotation from case law on the admissibility of computerized record keeping printouts. The top of the page is the essential quote from the case of McMullen. The argument that's built up in the paper is this: the Ontario Court of Appeal established that standard as being what is necessary for banking records. The case of Bell and Bruce, which is also dealt with in the paper, did not remove that standard. And that standard is given in the fifth line down from the top of page 273. That is that the foundation evidence has to be this, quote, "The nature and quality of the evidence put before the court has to reflect the facts of the complete record-keeping process. In the case of computer records, the procedures and processes relating to the input of entries, storage of information, and its retrieval and presentation." Now that is a case which has come along at a time when that expression, usual and ordinary course of business, is in our banking legislation. That phrase, usual and ordinary course of business, is also the essential phrase in the sections dealing with business document legislation, in Section 35 and Section 30 of the Canada Evidence Act. That phrase, usual and ordinary course of business, is the essence of Bill S-33's provision. Therefore, it should be very reasonable for a court to apply McMullen to S-33 if S-33 becomes a new Canada Evidence Act. Therefore, McMullen will therefore establish the nature of the foundation evidence necessary. And therefore, all that I've said about getting into the circumstances of the making will become very relevant. McMullen requires it. The nature of the legislative wording requires it. Now, if that is what is required for banking records, then all the more, that is the McMullen standard should require even that and more of business document records. The Crown obtained admissibility in the case of banking records in McMullen and in Bell and Bruce, that is of computer printouts, by stressing the fact that banks are a very well-regulated form of business activity. Well, therefore, it should follow that even more should be required of business records which come from institutions that aren't banks. That is, I think, just another reason why the legislation should occupy the field. We should establish the criteria in the legislation, prevent the courts from fragmenting the case law so that we have a great multitude of possible factors. It's not only the lawyers and courts that are involved here, it's also the data processing industry. Thank you.